But yeah, it's not like a war song, it's a war song.
Hiyo ni ile ya kutoka kwa
Sasa, prosecution wanataka
anasema the key witness ambaye ni mother-in-law. Sasa hiyo kesi kiendelea kuproceed hawata make any progress. Wakujua na gari
hapana, wameimba Uhuru Wito, siwezi kujua. Amesema Uhuru Wito. Ndio naambia gari ya wali siku bosi wetu. But hiyo song ilikuwa inapigwa tele. It's a song.
kama wote.
But yeah, it's not like a war song, it's a war song.
Hiyo ni ile ya kutoka kwa
Sasa, prosecution wanataka
anasema the key witness ambaye ni mother-in-law. Sasa hiyo kesi kiendelea kuproceed hawata make any progress.
Or on instruction of the Director of Public Prosecution at any time before judgment is pronounced, withdraw from prosecution of any person, and upon withdrawal under Section 87A, if it is made before the accused is called upon to make his defense, he shall be discharged. By the discharge of an accused person shall not operate as a bar to subsequent proceedings against him on account of the same facts. Section 210 of the Criminal Procedure Code, quote, if at the close of the evidence in support of the charge and after hearing such summing up, submissions or arguments as a prosecutor and the accused person or his advocate may wish to put forward, it appears to the court that the case is not made out against the accused person sufficiently to require him to make a defense, the court shall dismiss the case and shall forthwith acquit him. End of quote. Section 204 of the Criminal Procedure Code provides, quote, if a complaint at any time before a final order is passed in a case, under this part, satisfies the court that there are sufficient grounds for permitting him to withdraw his complaint, the court may permit him to withdraw it and shall thereupon acquit the accused person. End of quote. The sixth schedule on transition and this is the sixth schedule of the Constitution on transition. Quote, all law in force immediately before the effective date continues in force and shall be construed with the alteration, adaptation, qualification, and exceptions necessary to bring it into conformity with this Constitution. End of quote. The application and the responses revolve around the above provisions. For clarity and as a way of distinction, the last amendment of the present Section 87A was in 2012. This was way after the effective date of the Constitution. Hence, any alteration, if intended, would have been introduced at the subsequent amendment. Testing Section 210 under the present position, it is instructive and unequivocal that Section 210 of the Criminal Procedure Code only relates to circumstances after the close of the prosecution's case which is not the case herein. Section 204, on the other hand, relates to withdrawal of complaint by the complainant. As is the practice, such withdrawal is only made on oath, which is not the case herein. What then is the recourse under the circumstance? As pointed out, the provisions the prosecution sought to employ withdrawal of the case herein under Section 87A of the Criminal Procedure Code. The end result is not in contest, that it result, if allowed, to a discharge and does not bar subsequent charge of the accused person on account of the same facts. This is not a termination of a case per se. The case would remain alive and at the whim or discretion of reinstitution by the prosecution. The case shall remain hanging on the neck of the accused person. The accused person shall live in perpetual fear of rearrest and reinstitution of the charges on similar facts. In deciding whether or not to allow the application, the central principle to be borne in mind is whether the thresholds have been met. In exercising discretion under Section 87A of the CPC, the court must satisfy itself that the threshold for grant of such order is demonstrated. In this case, the prosecution has outlined 4 grounds as espoused above. The ground revolves on insufficiency of evidence to sustain the charge. As it stands, according to the prosecution, the charges as they are bare and unsupported. In the absence of the evidence, they find difficulty in procuring. 9 witnesses have testified as listed in the 4. It is upon reviewing the evidence recorded so far that the prosecution deemed it necessary to discontinue the prosecution of the accused for insufficiency of evidence under Section 87A of the CPC. The defense on their part, as much as they do not object to the termination of the charges, all the view that to bring closure to the matter, then acquittal would suffice. This charge, according to the defense, is prone to misuse, an act that would infringe to the accused person's right guaranteed under Article 50. I agree with the defense that discontinuance of the matter under Section 87A of the CPC would not bring closure to the matter, as it shall remain an active sword that can be swayed by the prosecution at their whim. The prosecution, on their part, maintained that it is not in possession of sufficient evidence capable of sustaining the charge, hence deem it proper to discontinue the same at this stage under Section 87A of the Criminal Procedure Code. The prosecution cites its inability to avail crucial witnesses to prove the charge, hence, as it stands, the charges against the accused person are not supported. The prosecution is silent on its potency to reinstitute the charges should the application be allowed. Taking a cue from Mr. Biko's submissions on proper utilization of the court's time, of what use would be to the court to sustain a charge admittedly not supported? What would be the party's cost implication of attending to a trial whose evidentiary portent is known and admitted by the prosecution? It is a not trial, in my view. Unsustainable trial, and sustaining the same would be, by extension, entertaining the abuse of the process of the court. In as much as I sympathize with the accused persons who have been subjected to this admittedly unnecessary trial for over 18 months, the only available recourse would be to allow termination of the case under Section 87A of the Criminal Procedure Code. This court's ruling is explicit as to the admission by the prosecution of its grounds for termination of the case, that is, the account of lack of evidence. Admission that the prosecution does not possess sufficient evidence to sustain the charge, to sustain any of the charge against any of the accused person. In the end, I allow the prosecution's application to withdraw the charge under Section 87A of the CPC. Each accused person is discharged accordingly, and I direct that the cash bail deposited by each of the accused person in court be refunded to the respective depositors. Those are the orders of this court.
I'll be seeking instructions from my client to take personal actions against the IO, Mr. Misoi. And as such, Your Honor, I apply that you supply, you have order I be supplied with certified proceedings and the ruling for today. I'll personally take actions against you. On behalf of my clients and perhaps my fellow defense counsel, we wish to thank the court for the time it has taken, the resources it has expended towards this trial, and the patience within which the court has accorded to all the parties. We highly appreciate, and should there be a recommendation to a higher bench, be assured that I shall be one of the referees.
Amen.
And as such, Your Honor, and on behalf of my clients once more, allow me to wish the court a Happy New Year, a Merry Christmas, and Happy New Year.
No, I made a request.